In India, menstruation always been a whispered topic. We hide pads in black plastic bags and skip schools because lack of toilets. But in earlier 2026, that whisper turned into a constitutional roar. Today, we're diving into the Supreme Court judgment on menstrual health that everybody's talking about. It isn't just a landmark judgment, it's a massive legal patchwork that's going to change national policy framework on menstrual hygiene. On January 30th, 2026, the Supreme Court of India delivered a verdict that could change everything for 350 million menstruating people. In the case of Dr. Jaya Thakur versus Government of India, the court officially recognized menstrual health and hygiene as a fundamental right as an integral part of the rights of life and dignity, bodily autonomy, equality, and education under Article 21 and 14. Under the Right to the Educational Act, the court ruled that free doesn't just is waiving tuition fee, it requires removing any financial barriers, including the cost of sanitary pads. The court's logic was simple. A period should end a sentence, not a girl's education. What does this mean legally? Free pads for school. All schools, government and private, must provide free oxidizing biodegradable pads. Schools must establish dedicated menstrual hygiene management corners to stock up the spare uniforms, innerwears and disposable bags for emergencies. Mandatory toilets. Functional gender segregated toilets with water and soap are no longer facilities, they are just a constitutional requirement. When menstrual health is now right in schools, what about workplaces? This is where the debate gets intense. There is no national policy for paid menstrual leaves yet, but states like Karnataka and Bihar are taking lead. In late 2025, Karnataka became the first state to mandate 12 days of paid menstrual leaves annually per person in both government and private sectors. Bihar has quietly provided 2 days of paid menstrual leave for government employees since 1992. But wait, if states like Karnataka and Bihar are taking autonomous decision on menstrual health, why didn't union government make it a national policy? In March 2026, the court refused to mandate national paid leaves, citing concerns that might lead to workplace discrimination. They feared employers might hesitate to hire women if a 12 days biological tax was mandatory by the law. Instead, they have asked the center to frame model policies for the states to follow voluntarily. Even though the court is cautious, Parliament is still moving. A new private members bill, the Menstrual Leave and Hygienic Bill 2024, was recently introduced. It proposed 2 days of paid leave per cycle for all working women and students. Every workplace over a certain number of employees would need a board to see the benefits. Rules to ensure women's medical date and leave requirement for the private. Why does it matter? Because period poverty isn't a health issue, it's an economic one. When 23 million girls dropped out of school every year due to a biological process, India loses massive chunk of its future workforce. The 2026 ruling shifts the conversation from charity to biological citizenship.
It says that the state is responsible for neutralizing the disadvantage of people facing just because they are menstruating.
What do you think? Should menstrual leave be a mandatory national law or should it be left out to the individual companies to decide? Drop your thoughts in the comments. For more deep dives into the policies that shapes your life, don't forget to like, share, subscribe to Philos Factory, powered by curiosity, driven by facts.